So,
All right, well, I have the top of the hour if we want to go ahead and get started
back in time.
there. And Shannon, I think, oh, there we go. I was gonna say, if everyone can mute themselves, that would be fantastic. And then we can unmute as we have questions, so. And welcome to everybody. I see we've still got some folks popping on, and hopefully we'll get up. I know we had quite a few registered. This has been a really popular topic, so I imagine we'll start. We're at about 30 now. I think we'll probably reach upward of there. So
For sure.
our screens are going to get really crowded here and even more crowded in just a second. So, but welcome to everybody. I'm Byron Cordes. I'm the president of NACCM. And so hopefully we've got some folks from all over the spectrum, and I recognize a good number of you, but I love that I don't recognize another good number of you. That means that there's a lot of CMCs out there, and I can't know them all. So thankful to you all. And Julie Wagner did put in the chat that if you know anybody who isn't a CMC, or if you're not a CMC yet, we do have the window is open until tomorrow for the spring testing exam. So if you know anybody, please ask them to get their application in, and then they can sit for the test in April. Is that right? I think basically
April.
the month of April. Then they can choose a testing time once they're approved to take the test. So with that, I will introduce. Unless Julie, do you have anything else NACCM wise to say hello to everybody?
No, just I'm super excited that we have such a great group today. We had over 100 people sign up, which is unheard of. So Sean, your topic must be very popular. So we're excited to have everybody here today, and thank you for coming.
Yeah.
I'll turn it back to you.
So good. Well, I will quickly introduce Sean Hughes. He is a colleague here in the San Antonio area. I've known Sean for a good 20 years, probably. If you can say anything nice about a person, I can probably say it about Sean. He's just a stand-up guy with a lot of integrity. He's an attorney, but he's the good kind. He's the kind we like. And he was, I met him when he was in private practice, doing estate planning and guardianship, trusts. And so 10 years ago, 12 years, how long have you been in banking now?
Yeah, about 10 years.
About 10 years. He went over to the dark side and moved over to one of the banks. He's at Jefferson Bank right now, and senior vice president of estate and trust office for Jefferson Bank. And just a wealth of knowledge. He gets care management. That's the other beauty of it. So he understands how care management, trusts, and legal kind of all blend together. So Sean, I'm going to let you take it. You're going to talk to us about kind of financial powers of attorneys and pitfalls and pros and cons, and I'll let you go. Sean,
Okay. Well, hello, everybody. And Byron, thanks again, Julie, for the chance to share with everybody. And, you know, I feel like this group is near and dear to my heart, because I've worked so closely with, care managers, aging life care specialists for so long. So Byron mentioned, so I was in the private practice of law for a little bit over 20 years before I joined. About 10 years ago, I went onto the bank side and started working in the trust department. But a lot of what I did was guardianship. And a lot of that had, of course, there's just the normal capacity issues. There's family dynamics. We're looking at alternatives to guardianship or, conservatorship in some states. We are dealing with family dynamics. We're dealing with judges and legal documents. And so most of what I know at this point, I've learned from making big fat mistakes. So I have just pounded my brain at times trying to figure out, how do we make a situation work with an individual utilizing a power of attorney so that we could avoid a guardianship. I've had lots of times where There were different types of powers of attorneys we were looking at when someone could actually sign a power of attorney in those situations where capacity was questionable. Gosh, we've just run the gamut on those, on seeing some of how they do work and how they don't work. And so it's been helpful to be on the, everything from guardianship, somebody that, like, I would file the application on behalf of a family member or friend who is seeking to become the guardian. I have served as guardian ad litem many times, where I serve as an officer of the court to come in and evaluate a situation when we're just looking at care situations, trying to either avoid a guardianship or just make sure somebody's cared for, and try to figure out what could work or what wouldn't work in this situation. Been an attorney ad litem, and then of course, just in my practice, work with families who, families are complex and they're messy and they're beautiful and all of the above. And some days I felt like I was making the biggest of difference. And some days I felt like I was just, needing to go see my own therapist a little bit more because it was so difficult. So what I thought I would do, I've got far too many slides to probably share today, but we'll kind of just see how this presentation goes and really just kind of see which way we need to pivot, or how much I need to hear from you, how much, maybe it would be helpful for me to go through some slides. One thing is the feedback will be good, but with this many people on the line, it is helpful to hear maybe a situation you have, a question you have, a story. But what I would have us all refrain from doing is, we all have an arsenal, a war chest of crazy stories that we've dealt with. And sometimes telling those stories, setting up the scenario, can take 10 minutes. We don't have time for that. So I would just say, unfortunately, because I'd probably learn a lot. So that being said, before we click, so what we're going to do first is go into the types of powers of attorneys. But is anybody willing to unmute and just tell me, what would you like to get from today's discussion as we talk about powers of attorney? What information that you can utilize in your practice with your clients, day in and day out?
I guess I will ask. This is Tina Lott, caring
Meeting
with
right
Grace.
now.
Can you hear me?
Hi, Tina. Yes, thank you.
As a company, is it, we're looking at doing medical powers of attorney within our company for clients, and then how does that, or how do we set that up as a company? Do we can name individuals within the company, or is it the companies? And is that really still a feasible thing to do, if that makes sense?
And so that's just medical, not financial?
Yes, no, not financial.
Okay, we'll put a placeholder and come back to that. What else?
This is not a bashful group. Somebody else has to have it.
I'll ask a question. Hey,
Okay, thanks, Cheryl.
this is Cheryl. So my main question is, what have you done to actually encourage people to fill out the paperwork that is needed? So many people, I mean, there's so many reasons why, but what has worked in order to actually have them fill it out?
Excellent question.
And thanks for being here. It's a great topic.
Thanks.
And Leslie, I see Leslie too.
Yes, thank you. Some clients can't really afford to go to an attorney to do some basic documents, such as a power of attorney. Some states provide standardized forms. I prefer my clients to use an attorney for things like this, just because of nuances that could be unique to their situation. But sometimes either they don't want to, they can't afford it, or time is an issue and we need to get something set. So I'd like to know your feelings about using standardized forms and appropriateness or not of a care manager assisting with that process and arranging for a notary.
Great, excellent question. Yep, we were definitely going to touch on that. Thanks, Leslie.
Thank you.
And can I quickly just, if any other questions, but if folks can mute unless you're asking a question. I see a couple of people are unmuted and we're getting some breakthrough sound from you.
Okay, any more questions before we jump in? Okay, well, feel free to ask them along the way as well. And then we'll have some spots along the way. So if you think about powers of attorney, remember that we're talking about, so a power of attorney grants, so the person signing the power of attorney is typically referred to as a principal. And we can act. We can act for all of our finances, all of our medical, all those things. We can do that unless we have like a guardianship, or unless we're incapacitated. Remember, a guardianship is when a guardian is named, a person's constitutional rights are taken away. So we certainly don't take that lightly. And so again, we're trying to appoint an agent to step in our shoes in the situation that we're unable to make these decisions, so that they can make medical and they can make financial. And today we're going to be mostly talking about financial. We'll touch on some medical, and we can always follow up with another session on medical power of attorney if that would be helpful. But I want you to just kind of think about some of the basics. So you might hear something called like a general power of attorney. And what a general power of attorney is that's basically a document that gives broad authority to the agent to act. So we're basically saying, hey, look, and I'm going to give you some examples in a little bit, but in Texas, we have something called a statutory durable power of attorney. And that is basically saying as the principal, I'm giving the agent authority to act in all these different ways. A limited or a special power of attorney is typically for a limited amount of time. Like think, for instance, when my kids were young and I was going out of town, and I might say, hey, like on a medical side, in the event that, while in our absence, I'm appointing somebody as a limited medical power of attorney. Or sometimes you might have seen when sometimes somebody will be selling a piece of property or conducting a business transaction, and they'll say, for this limited time, for this limited purpose, I'm granting someone else, an agent, the authority to act on my behalf. And then I already mentioned kind of like this durable. What a durable power of attorney means is that it's not for a limited time. If the durable power of attorney, if when you sign it, if the document says it's effective immediately, then it stays in effect until it's revoked. So it's durable through incapacity. So for instance, you might have authority as the agent today. The principal might become incapacitated. You're still the financial power of attorney. And then the principal might become better and from some health issue they had, and you're still the power of attorney. And then of course, other things we talked about, healthcare directives, medical power of attorney, directive to physicians, often called a living will, a HIPAA authorization, a declaration of guardian in the event of incapacity, those type things. So on the powers of attorney, I love the question. Look, it was Leslie that asked about the standardized forms, and thinking, gosh, not everyone can go and afford to get these specifically tailored powers of attorney. And so whereas, gosh, all of us, I think, would agree, we'd really rather a client go to an attorney and get a specifically crafted power of attorney just for their situation. There are times when a standardized power of attorney can work, and there are times when a care manager could help out and get that done. And we'll touch on that a little bit more. So one of the things that I think is just foundational is the fact to remember that anyone who's serving as an agent under a financial or medical power of attorney is serving as a fiduciary. And so they have to understand that you have this duty to act in good faith. You have a duty to be loyal to the principal. You can read here, exercise care and prudence, keep accurate records. I will tell you, and then of course, self-dealing which is you can't sell, you can't become agent over someone and then all of a sudden make a transaction that you're the big beneficiary of that was not in the best interest of the principal. So you can't self-deal. And then number 8 here talks about full disclosure. When I go to fiduciary litigation seminars, oftentimes they'll say, do you want to know the best 3 ways to keep yourself out of court on a power of attorney? And they'll say transparency, 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 or disclosure, disclosure, disclosure. And so very important to know that when you are working with a family member, to have someone appointed as an agent under power of attorney, or whether you or your agency is an agent, make sure that you set your expectations up front and then communicate with everybody of the fact of disclosure, of good communication, of good record keeping, so that if your actions are ever called into question, that you're able to show that you have maintained confidentiality, you have acted for the principal's best interest, you have disclosed. So those are really important as well, just kind of that basics of a fiduciary duty. And then I'm going to stop and see if we have any questions here after this one, but good question is, what is a breach of fiduciary duty? Like, when would you find yourself in a lawsuit involving this breach? So one of the very main things that we see is when an agent does not act in the principal's best interest. So somebody's, appoints a neighbor, a grandson, a family member as the agent, and they start stealing money, or they do things like that. I'm sure no one on this call has ever seen a situation like that, but thinking maybe once or twice. Again, placing your own interest above those of the principal, failing to disclose, and then, on that number 4, the biggest thing is to think, how will this, if I'm acting as an agent on behalf of the principal, how will this affect the principal? Is it going to be in their best interest? Is it going to be detrimental to them? And those are the things that you really have to think through. So,
And Sean, can I
stop there.
I just to play off of that, for I think too, I don't remember who said it, but that they're looking at adding financial power of attorney to their care management practice. And I know lots of care
talking about medical.
Yeah, well, or even financial. So I guess that's where I was going.
Yes, or even financial. Yes.
Okay.
Yeah. Oh, Tina, that's it. Thank you, Tina. And so, we've avoided it even just for the potential conflict of interest. Can you address that as how could a care management company, because there are care management companies that do both. They do financial and, medical power of attorney, but almost in either one, they're making decisions. They're kind of appointing, right? When they're financial, they're paying themselves, right, to be the care manager. How can you address that potential conflict of interest if you're making decisions, but you're benefiting financially from those decisions? You could potentially be benefiting financially. Let me say, I think it can be managed. I'm not trying to make it sound bad. I'm just trying to say, could you address it?
Yeah, so here's a good way to think about that is that I know, for instance, I work at a bank now. I work in a trust company, and lots of banks will let a client appoint them as an agent under a financial power of attorney. Some banks will even do a medical power of attorney. On the medical, I quickly say, look, we're a bank. What happens if you get sick at 5:05 on a Friday afternoon? How are you going to get a hold of us to get to the hospital? On the financial power of attorney, our bank has actually made the decision within the last year that we do not serve as an agent under a general or a broad power of attorney. And I'll tell you why, but the only way that we serve as agent is under a limited power of attorney, where someone is they have a trust and they appoint us as a limited power of attorney for the sole purpose of gathering assets and funding a trust. And the reason we do not serve as agent under a general or a broad power of attorney is that after talking to many of my colleagues who are fiduciary litigators, we have found that there's so much gray area in the question of what would the principal have wanted me to do? Because like, if I'm serving as a legal guardian of the estate, I have, like in Texas, we have some very specific, I guess, tasks that we can, by law, perform, and some very specific, expenses that we can pay by law that are in the code that we can just use. Otherwise, we go and we get court approval. So in the guardianship realm, we have the code, and then we have the court to help us stay in our lane. For me in the trust department, we have a trust instrument that tells us exactly what we can pay, what we need to consider, whoever created the trust wants the principal or the person receiving the trust to benefit. And so again, we have a very clear guideline. In a power of attorney, you're literally, if you're the agent, you're stepping in the shoes of the principal. And what would the principal have decided in many situations? Sometimes it's clear, sometimes it's very unclear. It's really easy for somebody who's a family member who's never stepped up before, but now they play Monday morning quarterback and they're like, well, you should have done this and you should have known to do this, because if you're stepping in the shoes of the agent, of the principal, you should be doing this. So for us, it's a real gray area. I would say that as a care manager, if you're serving as a fiduciary, specifically as an agent under a power of attorney, I'm guessing that if they're just appointing you, there's probably not a lot of assets. Maybe there are, a bit of assets, but what I would do is make sure that if you're going to do any investments, make sure you pull in a very trusted investment advisor. If you are going to make decisions that have any legal consequences, make sure you pull in an attorney. If for taxes, make sure you pull in a CPA, and then really document your file. So for us, we are, my bank, we're overseen by the FDIC. So we have to really document our files as far as some decisions that are made. It's real similar if you ever found yourself in a breach of fiduciary duty allegation, that you could go back and say, hey, this is exactly what we were doing. And for instance, we were making charitable contributions to their, church, their synagogue, wherever, because the principal had a pattern of doing that over the years and wanted to continue that. Or we did this expense because there was this medical reason. So if you are really good about documentation, it can work. It's just a matter of making sure that it's kind of like any profession, you just have to be very careful to document. Is that a little bit helpful?
Yeah, and I think you also hit on something else, kind of the checks and balances, like you said, making sure that you have, good advice from attorneys, CPAs that are helping you kind of stay in your lane.
Yeah,
that was
and
excellent.
I'll tell you this, one thing when I was younger, and in that I tried to do everything on my own, but even like here at the bank, we really know, I've really been reminded again that I have gifts in a certain area, but we reach out all the time to experts in other areas and just say, hey, give us your thoughts on this. And I know that sometimes that's hard because you can't afford to go hire an attorney in these situations, but maybe you have a good community that you could at least consult and put a memo in your file that says, I consulted with this, with an attorney, and here's what we have. So something to think about. Okay, so one thing to think about is how powers of attorneys vary from state to state. So as you can see here, there's a Uniform Power of Attorney Act that was created in 2006. And so far, I think it's 29 or 26. I'm questioning my my numbers here, and I'm going to flip to the other screen, and then I'll be back here. But yeah, it's 26. Yeah, 26 have adopted the Uniform Power of Attorney Act. And the reason that's important is because so many of us have clients that are, moving, either they've retired, they're moving somewhere else. Texas is just getting Californians by the dozens. We we get lots and lots of folks here, and then, or somebody's moving closer to be, moving to be closer to like a child or a family, something like that. One thing you might check is, or a question I get a lot is, hey, Sean, I've just moved from Oregon. Is my power of attorney valid here? Well, I know that in Texas, we have a specific statute that says, if your power of attorney is valid in the state in which it was executed, there is a reciprocity here where we will honor that power of attorney. Now, here's one thing that I'm sure some of you have seen. That's what the document, I mean, that's what the law says. However, a bank, a brokerage company, a financial institution, a life insurance company, an annuity company can say, this is really not the form we're used to. We're not going to recognize it. And that's a tough situation, and you might have to kind of dig in there. But the purpose of this Uniform Power of Attorney Act was at least to have an option where it's going to be a little more standard. Any questions on that, kind of the forms or the when it, state to state or anything like that?
Yeah, I have a question. What about a guardianship or conservatorship in another state?
Yeah, that's a
If a
great
client
question,
moves
Brenda.
from one state to another, because I know it's a sort of gray area.
Yeah, well, in Texas, what happens is we do need to move them. So when I was in private practice, oftentimes, if I had like, let's say there was a guardianship established here in Texas, and they were moving to Pennsylvania, we would need to transfer that guardianship to Pennsylvania and have a motion with the court in Texas. And then we'd have to go hire counsel in Pennsylvania, and they'd have to open a guardianship, and it would be transferred. Same thing, we have received guardianships from other states as well. And so in Texas, they make us do that. Yeah, great question.
I see Emma has her hand raised.
Oh, hi, Emma.
Hi, thank you, Sean, so much. A dearest friend of mine lives in Houston and is wanting to do her power of attorney. So is that transferable to other states?
Yes. So, well, I was going to say, it depends. So I would say that probably if any of these, if she's moving from Houston to,
California,
okay, yeah, somewhere like that. Okay.
wherever.
Yeah, let's say that hopefully they will recognize it. It really depends state by state.
Okay.
Now, any of these in blue should recognize a validly executed power of attorney. And it's interesting too, because, let's say that she has her bank account with Bank of America or Chase or PNC, these big national banks. They're used to looking at powers of attorney that cross state lines, et cetera. Some of the smaller, more local or regional banks, community banks, sometimes they're like, I'm not sure about that. And so one thing that I always recommend is when you have a client that moves, run it by either a friend who's an attorney or run it by, some colleagues who, you work with and say, hey, got somebody that just moved in, out of state power of attorney. What do you think here? And sometimes it's really worth, actually all the time, it's really worth asking that question up front, because if a situation becomes acute and you're walking into a bank, a financial institution, wherever, trying to utilize that power of attorney, and at that point, if they say, sorry, it's no good, then you have to get a guardianship or conservatorship. So something to think about is, and again, you're probably all really familiar with this, but when is a power of attorney effective? And so there are two options. The first one is you can just say this power of attorney is effective immediately and is not affected by my subsequent disability. So you can just say right now it is effective. Let's go. Number two, upon incapacity, and we often refer to this as a springing power of attorney. And one kind of way to remember that is it literally like springs into effect upon incapacity. So it's not valid at this point. Now, the only thing about that is with option two is that for the agent to be able to use a springing power of attorney, they do have to have a a letter from a physician stating that that person has become incapacitated. And sometimes that's difficult to obtain, and sometimes it's not so bad, but it's just an extra step. And I'm not sure if I have this another place, but here's a question. Does a financial power of attorney need to be recorded, like recorded at the courthouse, recorded in deed records? It does not, unless you are going to, or you anticipate some kind of a real property transaction. So let's say that mom appoints her daughter as financial power of attorney, and mom starts slowly becoming incapacitated. Well, at some point, the daughter is saying, gosh, I think we're going to have to sell mom's house and move her into some kind of a care facility or in with herself, whatever. But mom doesn't really have the authority or the capacity to understand the closing documents and all that kind of stuff. So the only way that daughter can sell the house is if the financial power of attorney is filed in the deed records. Because if, like, let's say that, in that situation, let's say I appointed my daughter and I became incapacitated and she was like, I'm going to sell your house. And so she signed on here, Hannah Hughes as power of attorney for Sean Hughes. And people would say, that's fine, but under what authority are you signing as power of attorney? We need to see the document. And that document needs to go with the deed to be on record in that county of the sale. So something to think about there.
And Sean, there's a question in the chat.
Yes.
Sheila asked it. Go ahead, Sheila.
Hi, Sheila.
Good morning. Okay, so I have a situation with a client who's extremely intelligent, super smart, still with it,
Yep.
lots and lots of money. Son has been appointed his power of attorney, and it's immediate.
And that's a
Does that mean
financial
that
power of
this-
attorney?
Yeah.
Okay.
Does this mean that the son could step in and make decisions on his dad's behalf against his wishes?
So that's a really good question. So when the principal, the dad in the situation, executes a financial power of attorney that says it's effective immediately, the son, first and foremost, is stepping into a fiduciary role. So your question of, I guess I can flip some of the wordage. Should he make any decisions against his dad's wishes? Absolutely not. He should not. Can he? Yes. But if he does, would it result in a breach of the fiduciary duty and he is opening himself up to lots of lawsuits? Yes. Now, the other thing too is, remember, the father can, if the son starts doing something like that, the father can revoke that power of attorney as long as he has capacity to do it. Now, we all know with family dynamics, sometimes if the dad is not good at engaging conflict, or if he has enabled a child for a long time, again, I'm thinking one or two of us has had that typical scenario where you've got the one child that's never flown the coop and is still living off mom and dad. So it just happens. It just happens a lot. And so oftentimes parents will turn a blind eye and let children like that kind of abuse the power of attorney. So he can, but I tell you, I'm so glad that that gentleman has you in your team involved, because you can help watch out for that situation. So yeah.
So what do you do in that situation? I mean, it hasn't happened, but it's slowly moving in that direction.
Yeah. So
Yeah.
someone else can chime in on this. My recommendation is to watch the bank accounts, watch the bank statements. I would even probably reach out. So if the father has done that and he still has capacity, maybe reach out to his investment advisor, to his banker, and just say, hey, look, I want you to know I appointed my son and he has this authority, but I don't want him moving large amounts of money. And I don't want him doing anything crazy. Now, that being said, the dad's already signed the document. The son can probably move it. The bank's probably going to say, look, we can't micromanage all this, sir. You signed the power of attorney. And so at some point you might have to hire an attorney and get a guardianship instead if he becomes incapacitated, or up front, you can, kind of coach him if this is really what you really want, and maybe he wants to revoke it. So,
Okay, thank you.
yeah.
And Cheryl, I think Cheryl may have something.
Yeah. Hi, Cheryl.
Hey, so I used to think that because usually people don't have their financial powers of attorney created, then something happens and the family needs to access the money, or someone dies, they go, well, I guess there's two different scenarios, but say they're alive
Yeah.
and they go to mom and dad's bank and say, okay, well, what do I need? So it seems like each bank has their own form that they want to fill out. And recently I wanted to know, like, what would Wells Fargo need? And so I called them and they said that they need the financial power of attorney filed with them by the person who has the account while they're still able to, while they still have capacity and they're not in the
Wow.
hospital. So early.
That's a big burden.
Right. So that's what I'm wondering, like, when I'm coaching people, as far as, it's important to fill out these documents, but often if they just have the financial power of attorney in their hand, that does not, in my experience, it doesn't really allow the person, the agent, access to their banking accounts. They just still have to jump through some more hoops. So wondering what your.
Yeah, I will tell you that that brings up such a good point, in that I remember over the years, I would as an attorney or something, I'd draft these documents, we'd work on it, I'd get it to the clients, and the clients would call back, a week later, and they'd be like, you didn't give me the right document. And I'm like, well, tell me more about that. And they're like, well, I took it to Wells Fargo or whoever, and they wouldn't take it. And I'm like, okay, great. And I'll tell you, there's no magic answer there, because it is banks can make different decisions. Now, that being said, I will tell you, what I have found is I really do think that Wells Fargo example you gave is a little bit more in the minority. And maybe more banks maybe the national banks are going to that now, just in an attempt to minimize the fraud. I don't know, because in that situation, you have to consider what are the tools that the law allows before guardianship or conservatorship. Well, it's, power of attorney. It's someone putting another person on an account, which I'm kind of a fan of, in that, like, let's say that when I'm doing estate planning with someone, or when I'm talking to a family member, I will ask them, so yes, you've done your powers of attorney, but first I'll ask them about their family situation. Like, I'll be like, is there a trusted son or daughter or another family member that would be able to step in the event you're incapacitated? And they might say, yes. Well, tell me more about that person. Then when I feel comfortable, I'll say, you might consider adding them on your account. They doesn't have to be like payable on death to that person, doesn't have to be a beneficiary designation. They can even be a convenience signer. But that way, that person has the access to the account without going through all the hoops of a power of attorney or things like that. Won't solve all of the accounts, but it can at least serve as an interim kind of stopgap measure to make sure bills are paid and all that. There's access to funds. So yeah, that's a tough one.
I just wanted to step in, Sean, and say, you were talking, some of the national banks are probably used to seeing, powers of attorney from all over the country, so they might be better. In my experience in care management, that has not been the case. It's usually the smaller banks, regional banks, that you can kind of reason with, or you can get the attorney that drafted it on the phone with them and tell them. In my almost 30 years, I've seen Bank of America accept one power of attorney. Typically, they've turned every other one away, dozens.
Which is a great point. So I know in San Antonio, there are 3 community banks. And even when I practiced law, that's where we sent everybody. Please go to one of those 3 community banks. So I would also find a trusted contact and a more local bank that you can at least have as an option. Now, that doesn't help if somebody's just banked with Chase their whole life, or PNC or Bank of America, but you might think about that. So here's another good question of, when does a power of attorney end? So one thing you might look at is, you might have your state might have a statute that's similar to Texas, and ours says if they divorce and the ex-spouse was the agent, then it terminates. And then, of course, an agent in any time can decide, okay, I'm going to terminate this agreement. Some powers of attorney might say, you know, like I see people going for surgery, and they've said, okay, I'm going to appoint somebody as my power of attorney for the next 60 days, and then it terminates. And then, of course, when someone dies, and you might recall any power of attorney, whether it's medical, financial, whether it's limited, whether it's durable, it's going to terminate upon death. And so no actions under power of attorney after death. And then looking at your power of attorney, of course, always see, is it effective immediately or just upon, does it spring into effect upon incapacity? So here's a good question for everybody is, what in the world do you do with the originals and the copies when you sign it? You know, question marks over all these. What have y'all found are good practices? Anything?
We always scan in a digital copy and keep it on our drive so we can fax it easily.
Brilliant. Good job.
The attorney has a copy, of course.
Uh-huh.
All agents should get a copy.
What's that?
All agents should probably get
Yes.
a copy.
That is such a good fundamental comment there, because I cannot tell you how many times folks would come in for estate planning, and you know that there's a generation that doesn't like to talk about money, and they don't like to talk about incapacity or death and all that. And so they'll want to appoint their children, but then, or somebody, but then they don't even want to tell them. And so make sure the agents know and they have a copy.
Yeah, I was going to say my mother created a book for all of us. So I have a booklet with all of her plans in it, which is great because my sister is her financial power of attorney and she can never find her book. So my sister calls me frequently, hey, can you fax this over? Can you scan that in? Can you send me a picture?
You're like, you betcha. And then, of course, just, you know, talking about the medical again, make sure you send that to your physician's office, to the client's physician's office, or, you know, if they have a hospital, they have medical issues and they go there a lot, those kind of things. Now, one thing to think about is talking about a safe deposit box. One thing we've seen, I'm sure you've probably seen this too, is what happens if they take the originals, they've either given it to the agent and the agent has lost it, they've never given it to the agent, or the agent has an old copy or something, and they say, I'm going to put it in the bank in a safe deposit box. And again, they, you know, let's say the bank's a holiday and the bank's closed for 3 days and you can't even get it. So you don't know what to do. And so you just need to kind of think through a lot of those things.
And Sean, do you know, I know in Texas, the original and a copy are both valid.
Correct.
For all of our POAs. Do you know any state that requires it always be an original? Is that?
You know, I don't. Does anyone on the call know that if you have to have an original?
Sometimes the banks want an original just because they're being snarky and impossible, as people were saying earlier. They want originals, they want the person themselves, they want all kinds of rubbish.
Yeah.
And I agree that the smaller banks tend to actually be easier to work with than the bigger ones.
Mm-hmm. Yeah. Those are good questions. So, okay, I'm going to go through these next couple of slides pretty quickly, but it is important to know under a power of attorney, what can a power of attorney do? A financial power, an agent do? Now, remember, there's a caveat to all of this, is that the financial power of attorney usually has a list of things that the agent can or cannot do. So again, access the accounts, file taxes, make investment decisions, collect debts. If it's a limited power of attorney, you can't do all this. And so if I was going to redo this slide, I would say, what can a financial power of attorney do? And then I put subtitles that say, with specific authorization from the power of attorney. So it has to be in there. Now, I don't know if anyone else, do we have anybody else on the call from Texas except for Byron and I?
I see Jill Piazzi here in San Antonio.
No,
And
Dallas.
Tina
Dallas.
Lotz in Dallas.
Okay. Well, this is really interesting. In 2017, the Texas legislature amended our Durable Power of Attorney Act, and they started allowing that there were certain powers you could add to your power of attorney. They have to be added, but they're allowed. So look at number one. And I bring this up because I want you to go pull your state's form and see what all is on there. Because in our state, you would either check a box beside every power that principal wants to give the agent, or at the bottom, you could just say, they get all of the powers above. So it's usually like which powers and when is it becoming effective? So again, which powers and when does it become effective? Immediately or springing? So what the Texas legislature added is number one, that it says the agent can basically create, amend, revoke, or terminate a trust. Well, you start thinking, well, that's a good idea, because what if they need Medicaid eligibility, or what if there's something like that? That sounds really nice. And on the other hand, kind of creates a lot of issues. Now, making a gift, you might recall that there's an annual gift exclusion that I believe this year is $17,000 that someone can give. Like if you've got a parent and they have 5 kids, they can give every one of those kids and the spouses too, $17,000 each year. So they can make that gift. So if they have a pattern of gifting, they can still do that. Now, this is where it gets a little tricky, is create or change rights of survivorship. So let's say that in the situation that Sheila was bringing up earlier, where there was a father appointed a son, and the son was beginning to make some questionable decisions. Well, let's say there's 3 other siblings, and the son all of a sudden starts taking his power of attorney, if it was in Texas, and changing the survivors to himself. Well, clearly that's a breach of fiduciary duty, because it's self-dealing. Did he tell his dad? Did he tell the other siblings? Non-disclosure. And did he alter his dad's wishes? So not a good idea. So again, in Texas, they can create beneficiary designations. They can even delegate authority. So that's something to think about too. Under a power of attorney, you can't typically say, and really in any state, can you say, okay, it's that same situation. Dad named his son, and the son's like, well, I don't want to do it anymore, so I'm going to name my sister as the power of attorney. He can't do that. But can he delegate some of the authorities? Yes. Can he say, sister, I'm going to delegate the investment authority to you because you know how to buy good CDs for dad and buy treasury bills or invest in the stock market. I'm going to delegate the taxes to my cousin because the cousin is a CPA and knows how to do it well. But again, if you're going to delegate that authority, you want to make sure that the person you're delegating it to is responsible, is transparent, is, there's good records kept, all those kind of things. These hot powers have created a ton of litigation. So I'm not quite sure about those, but.
And Sean,
Yes.
could you address, so what if the financial power of attorney did not know that they were assigned? Can they refuse?
That's a great question. So in Texas, so anybody can refuse. Yes, you can absolutely refuse. So let's say that you were named and you were like, woof, we're not doing that. Up until a few years ago in Texas, it was kind of the case law that said, even if you're a named agent under a financial power of attorney, even if you don't know, then you still have a duty that you should have been aware and you should have known and all those kind of things. Crazy. They changed that to say, how in the world could you be held liable for something you didn't even know about? And so like you now have to not only have it and know about it, but you have to act upon it. And that was the big thing too before. It was really more of not only just knowledge, but did you fail to act? Should you have stepped in? And so it's almost the sin of omission. And so for now, you can definitely say, hey, sorry, like we'll get powers of attorney. Sometimes they'll appoint us at the bank and we write them a letter back and say, thank you so much for your trust and confidence in us. However, we don't serve. And so we want to do it in a limited capacity, we can. So again, this slide was pretty self-explanatory. Let's see here, just so you know, we've got about 11 minutes left. Okay, this goes back to Leslie's question on when or when not to use like either internet powers of attorneys or standardized powers of attorneys. So again, we have a really good judge in town named Polly Jackson Spencer, and she was on the statutory probate judge on the bench for like 26 years. And she kind of taught me that, you know, sometimes we have to think a little bit out of the box, and there's nothing like some good, just discretion and judgment. So just use some good wisdom. And so there are times like in a situation, if you're like, okay, look, this person has limited means, they clearly cannot afford to go to an attorney and get a power of attorney. What their needs are pretty simple. And there's not like there's people, you know, standing in line to help them, you know, just waiting in line saying, hey, let me serve. So in those cases, you can step in and say, okay, we're going to use the statutory form and we're going to go ahead and help this person. And so, you know, I can't give legal advice, but, you know, just use your discretion and your judgment. I think that could, and think, okay, is this a chance we could do it? So I hope that helps there a little bit.
And Sean, there's a question.
Yes.
Cheryl put in, how do lawyers and financial advisors decide if the person has capacity to enter into those legal documents? Is there a standard?
Great question. I wish there was a standard, and that's kind of a tough one because, like, for instance, there are different capacity standards under the law of, can you execute a will? Do you kind of know the fruits of your bounty there? Can you execute a bank agreement that's going to name a new agent, or I'm sorry, a new co-owner of your account or a convenience signer? Can you enter into a contract? You know, can you go ahead and appoint a power of attorney? So they're all a little bit difficult. And I will tell you that when I personally am in a situation where I'm just like, this is just too unsure. It's a gray line. I always, at that point, defer to the family physician or to someone that can see them from a professional capacity. And so I try not to make that decision on my own if there's a team of people or someone professionally that could make it from a medical perspective. Does anyone else have any thoughts on that? I'd love to hear it.
I have, in the past, I have worked with, I think one attorney in particular, who my client was actually deemed incapacitated, but there were times where he was as lucid as can be. And the attorney was able to make the decision, and of course documented it, that the attorney, or that the client understood what he was doing by, I think he was changing the healthcare POA, that it was clear, you know, what his intentions were and why. So,
Yeah.
you know, the attorney, I forgot exactly how he worded it, but he had those moments of clarity and lucidity, which many people with dementia do. You know, just because they're incapacitated doesn't mean they don't understand.
Yeah.
So.
Thanks for sharing, Sue.
Mm-hmm.
Yeah. In my experience in California, things can get very rigid. I was brought in 2 weeks ago. A colleague was helping a neighbor. I mean, she was a neuropsychologist. I'm a care manager. We had a professional fiduciary involved. The hospital, there was a day where he was completely lucid, and if the hospital had said, okay, he can sign documents, it would have worked. But he went downhill very quickly after that, and we didn't manage to do what we were planning to do because I understand they're very, very afraid of lawsuits, of the liability, and he was this in and out. So he's in and out today, but he's in and out tomorrow, and it can really work against you when you have someone who has these moments of lucidity.
Yeah, it's good. Thanks, Brenda. So one thing to think about that I've had to ponder many times when I was working in my legal career is that when is a guardianship or a conservatorship needed? Like, let's say you have a power of attorney, but you still have to pursue a guardianship or a conservatorship. Well, number one, if there's not a power of attorney for finances, let's say somebody appointed medical or they appointed a power of attorney, and like number two says here, the agent says, look, I'm not serving. I'm unable to serve, I refuse, or they breach their duty. And there's just not a good qualified successor named. So those are times when you're like, okay, we're going to have to go get a conservatorship or a guardianship. And the other thing is, we've talked about earlier with like our Wells Fargo example of a couple things. If a document is either too old, which shouldn't be too old, they could still recognize it. But if someone's not going, like a bank or financial institution is not going to recognize it, they reject it. Sometimes they're like, I'm not familiar with this, I'm going to reject it. Or sometimes there is, like, say, not specific language in the power of attorney that authorizes the specific act you are trying to accomplish. Then let's say it could get rejected again. And another difficult situation I've seen is, let's say sometimes let's say there's a gentleman who's starting to age and he's becoming super cranky and he becomes incapacitated. I hope that's not me at that stage, but we'll see. And then, like, let's say he's appointed a power of attorney, but he keeps trying to revoke it and he keeps trying to go behind that person's back. And even if the agent's really trying to do the right thing, if the principal's just stirring the pot and, really trying to just revoke it, then sometimes you have to go to court and get a court created guardianship or conservatorship. So let's see, naming multiple persons as agents. So in our Texas power of attorney now, it specifically gives the authorization that you can appoint multiple persons and they can both act independently. So you can also appoint one for medical, one for financial. But one thing I want you to think about is oftentimes really talk through families with who they're going to appoint, because they'll say, a lot of times they'll say, well, I'm going to appoint the oldest son. It would hurt his feelings if I didn't. And I'm like, the oldest son lives in Nashville and he never even calls you. Like, your daughter's right here. She's doing the work every single day. Why don't you think about appointing her? Well, she's the youngest. Well, but she's taking care of you. So, you just kind of can have those conversations. And so if I would say that if you name multiple persons, sometimes they need checks and balances, and that's okay. But really consider, is this just going to ease the burden or is it going to create more burdens? So let me think. I'm going to hit a couple things, then we can just close because we're almost at the top of the hour. Oh, this is in the power of attorney form in Texas. These are kind of some of the things that you go through and you check, like they can check, they can do real property transactions. Yes, they have authority to do stocks and bankings and estates and trusts. And then you kind of go down, this is the next one. They can apply for Social Security. They can do tax matters. And if you look at O, there's a place there they could initial there that say, hey, I'm going to give them all the powers listed above. So I'm going to do all that. And then this is an example of our Texas form. So for instance, it'll say, unless you direct otherwise, this power of attorney is effective immediately and it will continue until it terminates. Or you can choose one of the alternatives here. Like, you can choose to cross one of these out and have this become immediately effective, or have it a springing power of attorney. So you might kind of look for language just like this, or similar in your state's form. Because again, big parts of power of attorney: A, do they have capacity? B, who are they appointing and who's a successor? Is it effective immediately or is it springing? And what powers does it give? So those are the other things too. So that's just kind of a big overview of things to think through. What questions might we have in the closing moments?
We have a quick question from Cheryl. Any tips on what you found that people actually fill out the POAs?
Oh,
They
yes,
know
thank
they
you.
need it, but they don't do it.
Yep. So I will tell you, Cheryl, that is the $1 million question. We have so many people that just sit and sit on this. And sometimes what I have found is, when here at the trust company, when we think of estate plans, the attorney's the builder and we're the architect. So the attorney drafts the documents, but when somebody dies, we're the ones that says, okay, we're going to take those documents. We're going to actually build this out. We're going to be the architect to actually build out the plan. Here's who's going to be in charge. Here's where the assets are going to flow. Here's how it's going to do. Here's the timing, etc. I often do that as well with my clients of saying, okay, what are your assets? Who are the people in your life? If you become incapacitated tomorrow, what's going to happen? Let's build it out. I literally do take a piece of paper and do like a little chart and flow with arrows of here's what's going to happen. Here's where this asset's going to go. And here's who's going to have control or not control. And sometimes I have found when getting people to make powers of attorney, that if I sit them down and say, hey, understand that this is uncomfortable, understand you don't really want to do this, but if you do nothing, I just want to show you exactly what's going to happen. You know, whether that's the hospital's not going to know who to call. All of your siblings, if you don't have a wife, if it's a husband and the wife has already passed away, they all have equal right. What happens when they start fighting? What happens if they're on a ventilator and nobody wants to pull the plug? Do you want to stay on a ventilator? Well, what if sometimes the kids don't have reconciled relationships with you and they won't do it? I've seen people linger in the hospital for weeks and weeks because the kids don't have the emotional and relational health to be able to say, Mom, Dad, I'm going to let you die as gently as possible. So sometimes taking them down that road and playing out that scenario just says, hey, so to be real honest, this is how it could play out. Now, are you ready to do this? Or just stop there and then come back the next time and say, hey, what'd you think about my last conversation? Maybe it's time. Maybe that'll help.
Well, perfect. Well, we're at the top of the hour, so I want to respect everybody's time. I want to thank Sean so much. I pray that every one of you has a Sean Hughes in your area. I know I'll speak for Jill Piazzi and myself. I think we really appreciate calling you out, Jill, because I know you're in San Antonio too.
Hi, Jill.
We love being able to work with attorneys and trust officers that they get it. So thank you, Sean, so much, and being able to share your expertise. Real quick, I'll point out Julie has put in here, we have a webinar coming up in April on opioid. The opioid crisis, tentatively set for April 11th. So registration should open up soon. We're just firming that up with our speaker, but I think it's 98% there. And then, of course, the Aging Life Care Association. Many of you all are members, some are not, but we have our conference coming up also in mid-April in Minneapolis. The weather's supposed to be gorgeous. It's Prince's hometown, so wear purple. I don't know if Julie has anything, or Sean, if you have a closing remark.
No, but thank you. And know that it's really a team effort, and know that, gosh, these questions that come up all the time. I mean, I've been doing this for almost 31 years, and wow, there's not a day goes by that I don't learn something new. So don't be afraid to reach out. We can't do this by ourselves. We need one another. So thank you for the work that you do. This world it can be a beautiful place, but also a very tough place. And it really makes just people's days better. It makes their lives better when they have someone like you walking beside them. So thank you for what you do. It's just an incredible gift to this world.
Thank you so much, Sean, for doing this again. We appreciate it so much. And thank you to all of you for joining us today. And if you have other questions, feel free to send them to me and I can always forward them on to Sean. So thanks.
All right. Thanks, everybody.
Thank you, guys.